Sir, today I want to understand a very interesting Supreme Court case, Badrilal versus Suresh. Can we discuss it in simple terms?
Certainly, this case is about whether a will can be treated as revoked by a later compromise agreement and how that affects a sale of property.
First, what were the basic facts?
Mangilal was the owner of agricultural land. On May 6, 2009, he executed a will giving different portions of land to his daughter Ramkanya and to his nephews, including Suresh. Mangilal died on June 26, 2009. Just 6 days after the will, Ramkanya and Suresh signed a compromise agreement allocating the property differently. Later, in 2011, Ramkanya sold a big portion of the land to Badrilal. Suresh filed a suit claiming his share and said the sale deed was void as against him.
So the real issue was whether the will was revoked?
Yes, the entire case depended on whether the compromise agreement could legally revoke the will dated June 6, 2009.
Why did the Supreme Court say the will was not revoked?
Because Section 70 of the Indian Succession Act provides very specific ways to revoke a will. A will can be revoked only by a later will or codicil, or by a written revocation executed like a will, or by destroying the will with intention to revoke it. The compromise agreement did not satisfy these requirements. Mangilal was not even a party to the agreement. His thumb impression appeared only on one page and was not attested by two witnesses as required by law. Therefore, the will remained valid.
Did the agreement have any legal effect at all?
No, it did not transfer any property. It merely recorded how the property should devolve after Mangilal's death, which cannot override a valid will. So the agreement had no effect on the inheritance.
Then what happened to the sale deed executed by Ramkanya in favor of Badrilal?
The Supreme Court clarified that the sale deed is valid only to the extent of the share actually inherited by Ramkanya under the will. She could not sell the entire land because the land was never partitioned. She had only an undivided share and she could transfer only that part.
Does that mean Suresh's rights remain protected?
Yes, the court held that the sale is not binding on Suresh for the portion he inherited under the will. Since the property remained undivided, the parties would have to file a partition suit to separate their shares.
What is the most important learning from this case for law students?
The main lesson is that a will cannot be informally revoked. Section 70 is strict and must be followed exactly. Even a document signed by family members or bearing the testator's thumb impression is meaningless unless it meets the legal requirements. Another important point is that a person can sell only their own undivided share unless there is a proper partition.
Thank you, sir. This makes the judgment very clear and easy to understand.
You're welcome. Understanding these foundational principles of succession and property law is essential for good legal practice.